Right, everyone, welcome to our CLE on eviction expungements. We're excited that you are here and joining us. This is put on by the Access to Justice Office at the Utah State Bar, but we're doing it in partnership with some really wonderful folks. And we'll just kind of go over and introduce them now at the beginning, and then that way it won't distract from the main presentation. So I'm the director of the Access to Justice Office. My colleague Keenan Carroll will be joining us shortly. He's our staff attorney. And then we have Heather Lester. She is a housing mediation coordinator with Utah Community Action. She's going to be talking to us about rental assistance, the impact of evictions, and how we can start to get people help. Marcus Deegan is joining us from People's Legal Aid. He's the legal director there and an attorney who is frequently on the pro se calendars, as well as working in full representation cases. And he's going to talk to us about past efforts that were done to help clear evictions from people's records and how we needed change and what this new law is going to be doing for folks. And then we're going to hear from Nicholas Lloyd. He's an attorney with the Cullimore Law Office, and he is a very frequent fixture of the pro se calendars and evictions. And we're very appreciative that all of our speakers are willing to join us and bring in their unique perspectives. And ultimately, one of the biggest things that we hope people get from this is that no matter which side you're representing, no matter what your feelings are on evictions, the best way to go about this is to work together in partnership and to listen to each other and to work towards solutions. If you're just stuck in the problems, you're never going to get anywhere. And so it's moving forward through those problems to get to the solutions. So before we get started, the first thing that our office wants to do, of course, is to talk about giving service and encouraging people to volunteer. This is especially important in Utah for lawyers. We are asked to give at least 50 hours of pro bono service each year, and it's found in Rule 6.1. And volunteering with the Access to Justice programs that we offer is just one way to do this, of course, but it does give a real opportunity to improve access to justice for people in our communities. So Keenan is going to join us now, and he's going to tell you more about volunteer opportunities.
Good on over here. We have a wide range of volunteer opportunities for either side. If you want to be a plaintiff, helping landlords bring these evictions or anything like that, or if you're more interested in tenant work, there's plenty of opportunities on each side. I'm going to go over two main volunteer opportunities and then a low bono opportunities as well. We have we have what are called the pro se calendars. These are limited scope representation. And there's two different ones. There's eviction defense work on Tuesdays. The calendar goes from 12 to 5. Typically, you'll put in about 4 to 5 hours of work. Our office helps coordinate it, so we get the cases that are going to be on that day. If you're interested, I send out emails looking for volunteers. And then I send the case files and information to log into court so that you can log in and help out for the day. And we also see a lot come over on the debt collection calendar as well, which are on Wednesdays from 2 to 5 p.m. It's very similar to how the eviction calendar is set up. We send out invites to volunteers, and we send out case info, all of that. You just hop on, do the work for 4 to 5 hours, and move on. Both of these will be heavy with kind of what goes on after you hear about from Nick and Marcus about the different laws and and the new things that are going on. If you want to volunteer, this is a great spot. And like I said, it's limited scopes. You're only there for the day. Afterwards, it moves on along to wherever it goes, and your responsibility, you're no longer responsible. We also provide malpractice insurance if you do it through the bar. And so if you are interested, that's my email. We also have utahlegalhelp.org. We send out an invite list once a week, and you just respond to that. Let me know if you want to volunteer on any of those. We also do the virtual legal clinic. This one, there's 28 legal fields. The top 5 requested areas are family law, landlord, tenant, criminal defense, employment, debt collection. This has replaced what was previously known as Tuesday night bar, where you would come and answer a brief question. We get questions from everything from issues with tenants to issues with your landlords to everything. And basically, if you sign up to volunteer through this program, we send you the individual's phone number, an email, and their question, and you provide 20-30-minute consultation, provide them with either an answer for their question or direction on how they can get answers or help. So it's a great way if you want to just volunteer real quick on a legal question. We're always looking for individuals to sign up to do that. And again, utahlegalhelp.org is the best place to sign up. And the last one I want to get into before I pass it on to our attorneys here is the Modest Means program. Now, this is a pro bono, so it's an opportunity where you sign up for Modest Means, and you are agreeing to provide reduced fee services for individuals who can't fully pay for an attorney. And our office does the screening for this, so it covers anyone that fits in that middle range of 125 to 300% above the federal poverty guidelines. And we send out the referrals. If you sign up to be an attorney, we provide your information to the individual looking for help, and they contact you, and you're able to work around those reduced fee services that we have set up. Typically, depending on where they fall on the financial spectrum, we ask that the Modest Means attorneys charge $50 to $75 an hour. So it's a great way to provide service but cover some of the costs of service. And it's a great way to step into new fields, gain experience. And so if you have any questions, reach out to either myself or our office, and we'll help you kind of step into these fields. And it's a great way to get experience, and especially when you learn some of these new things that we'll talk about later today and you want to help, this is a great way to dip your toes in and get started. So I appreciate that. I'm now going to pass the time to Heather Lester and let her go. Okay. Thank you.
Thank you. I didn't know the order of things, but at least I don't have to follow either one of these two gentlemen. So I'm quite pleased about that. Yeah, just to start out, it's kind of hard to wrangle in what they're going to talk about with what I usually do. Mediation for Utah Community Action was initially a program that was Salt Lake County, Tooele specifically. And then as of January 1st of this year, we were able to take this mediation, well, for lack of a better term, take this mediation show on the road. So we were able to expand throughout all of the CAP network agencies throughout the state of Utah. So it's definitely been interesting, especially with different things that go into play with the, obviously the various courts, the, rental assistance programs that are statewide versus the programs that are city, county, state, private funding dollars, all of the different things. So I privy myself and I try my very, very hardest to always be up on the latest trends and availability for what can potentially help both sides. And so, of course, I'm surrounded obviously by lots and lots of people on this call that are of the legal mindset, and I'm in awe from everybody that could be potentially interested in this field, knowing what I do as far as mediation, working through a social service agency. It really does show how I can try to not just mediate neutrally and be that middle ground neutral voice, but also rally resources. And, sometimes the answer is just not yes, and that's fine. And it's very difficult with legal advocates or even legal activists that sometimes always want the yes. And so it's really good to have the perspective of working with both sides of the fence. But, going back to my PowerPoint slide, I mentioned that there are different types of assistance. I'm sure everybody on this call to some degree has had some exposure to the rent relief program. That's due to COVID specific rental assistance and deposit assistance for stability. But just understanding that CAP agencies, even homeless service agencies, there's a lot of different folks, not just nonprofits, but city, county, state funding that was present prior to COVID. And so understanding where that lives, number one, right? Because this is going to be important should you be working with a tenant or even a landlord that needs to understand where the money lives. And so what it covers is also the next thing, right? So some grants require certain documents, some require business licenses. Again, I do very much, I worked overly passionately about trying to make sure I know what those requirements are as we're involved, or even if just attorneys have questions on where that lives. So just understanding it's not just rent relief, because that's the new shiny toy in the game, but just knowing where they live and what grant types of situations can help even to stabilize the time period, maybe up and through the lease or the mutual lease termination. As far as mediation goes, there's no throttle, obviously, with income. We really do reach across the board. We don't have income restrictions. We don't have documentation status restrictions to helping whomever with mediation. So that's actually been very helpful. But the qualifications for rental assistance funds or deposit funds really changes from wherever the money lives. So it's a really hard question to say who qualifies and who doesn't. As we've seen now, most people did or have qualified for the rent relief program to some degree, but policies always change, thresholds always move, money gets spent out. Most places that have these funds are grant-based organizations. So it's really just something to help, someone like myself or my team can help to really work through the weeds on what that looks like and what's possible. So when we talk about accessibility to resources, it's not like, I never want to be the person that says, oh, yeah, Heather said we could just throw money at the situation that's going to fix it. Because that would be lovely. That would be super great. And we could always have all these rental units that anybody of any income threshold could qualify for. But it never is quite that pretty. As everyone's kind of smiling on the call, it's not that easy. So who needs to or who can apply for rental assistance? In the instance that it is a money situation, there is a notice requiring or some sort of a default on the lease agreement regarding to funds. I think it's good to try and wrap around those resources to see what's possible and what it covers. Again, some don't cover fees, or some don't cover arrearages, or some do not cover attorney fees and costs. And again, I think if there's an applicability for the tenants and the landlords to work together, because honestly, that's where really the rubber hits the road. The landlord and the tenant have to work together, regardless of whether it's landlords doing the application through certain grants or even just the tenant trying to run and get those resources. There has to be the main documentation that's required is, of course, the lease and the ledger, the updated ledger, the notices, income information, those types of things. So I can help to kind of work through that as requests come through for mediation. There's always the questions regarding assistance applications and history. I know that the eviction occupancy hearing calendar does also work through the debt collection calendar. So a lot of the times when people ask questions like, am I still able to get rental assistance? Have I capped out my rental assistance benefit? All of those questions come into place, and we can do the history on what's been paid, what could be paid, what's possible, what's covered. So just knowing that mediation does have that option as well to paint the picture for both sides, I think that can be extremely fruitful for anyone volunteering or doing this. I'm hoping that Marcus and Nick nodding, because I think it's helpful, and hopefully it really does bring a little bit more colors to the spectrum, so to speak. So timelines, oh, that one, I should have left that part out. Timelines are super fun because it's always been a juggle, right? There's TAP agencies, other nonprofit agencies that have had funding. The state obviously is doing the rent relief program, and it really depends. Like, is the application complete? Is it not complete? Are there missing documents? Are we going within a lease term ahead? Are we counting how many arrearage months prior? Timelines are difficult, and it's very frustrating, even for mediation, let alone what you guys experience doing this. But knowing that we're trying to drive as hard as we can, and we work on every single backdoor gray area that allows us to get in there and at least get a picture painted of what it looks like and what the expectations are. So we're out of any place that we're quite irritating and remotely annoying, it actually is helpful to get that idea of the timelines and how the, I don't know, whether it's a capacity issue with whomever's, doing the grant funding, or even if it's a delay on the landlord or the tenant side, we will have that information and to be able to provide clarity. So hopefully those things are helpful. There's a lot in that slide, but you can go to the next one. Okay, so we do a lot of stuff and not nearly enough. So it depends on really the situation. There's nuisance matters that are outside of payment issues. There are lease terminations, which we are currently in the throes of the lease term season. And then our friend inflation with rental increases and lease increases, and then re-signing leases. That seems to be spiking right now, but it's not due to COVID specifically. These things always happen between like June and September. People cycle leases, usually 12-month terms expire. It's not anything out of the normal. It just happens to be a little bit intense because there's not a lot of places that are open and or affordable. And a lot of times people can pivot into easily, especially if they have some sort of a barrier within the last, 24 months. So it makes it difficult. But with the initial negotiations that we try to do, it's really working really heavily with, all the big players, of course. I don't want to shout out too much because, everybody wants to always, see what Colmore's office is doing and then Jeremy Short's office and Dean's and Brad Carr. I'm shouting them out on purpose because I'm so thankful for the relationship that I've been able to work with them on, with the high volume of tenants that they work with, and also the high volume of landlords that are also scrambling and really having a hard time at this moment too. So just knowing that the negotiation discussions really do help with the stipulations, with the mutual terminations, and just, again, bringing that money to the table to at least make the eviction as painless as possible for both sides of the fence. I think I've repeated myself on the statewide program part of things. In the instance that you're working with any folks, please reach out to me directly. I am on the calendars for the occupancy hearing and can be available for the debt collection as well, just to have, bring what I can bring to the table, which of course is never to be misunderstood with legal advice, because that's left to all of your wonderful minds, but just knowing what we can line up to make maybe that stipulation a little sweeter, maybe an extension a little bit more fruitful. So the mediation, there's not just a quick number or a quick email address, although that's always welcomed in the instance that someone needs information. But should you want to refer anyone to mediation as a tenant or as a landlord, because we do have both options for referral, because we do work and take requests from both sides. There is, basically it's on our website, it's utahca.org, and there's a housing specific link that will go directly to that application. And obviously we work from whatever the ask is from that request. So sometimes that doesn't help by the time all of you wonderful folks get involved, because it's usually pretty intense and already filed on with the court. But just knowing that request exists. On Tuesdays, generally speaking, with occupancy hearing, we sometimes bypass or speed track that option because it's already on fire and we need to rally as much as we can. So I hope that gave a lot of information, but maybe likely not enough when it comes down to the multiple volumes of resources that are out there, and the more that will come. Obviously, it's usually on a fiscal year rotation. So fiscal year, a lot of grants get refunded, parameters change, get updated per the needs in the community. So it constantly is a growing, breathing animal. And again, I will help to do my very best to navigate that madness. So feel free to ask any questions should you have any, and I'm always here if needed. Thank you so much.
Thanks, Heather. That was really helpful. It looks like there was a question in the chat, and they asked, is there a list of assistance organizations you can refer us to? Is that something that's available in a list we can give to people, or are there organizations that you have?
It really depends on the need or the ask. If it's just rental assistance, yes, there's definitely a pile of whomever does normally process those things and do the funding. It depends. It could be a senior aging ask. It could be a veteran ask. It really depends. But yes, there is a working, breathing list of that as well. And I can definitely provide that. And it's usually done through the toolkit, through the coalition. That's usually the most updated list. But I'm more than happily provide that. I'll put my email in the chat.
Okay, perfect.
And I would just jump in too there and just say real quick, maybe this is before people are necessarily jumping in on a pro bono or volunteer basis at the calendar, but like if you know someone who's struggling to pay rent, rentrelief.utah.gov is a great resource. There's a lot of state money out there right now that can help people. So even if you're helping out people who need help before you're necessarily on one of these calendars.
And they have a referral list as well to a degree. And then also 211 is by default the easiest, just to, for that referral source. So yeah, Rent Relief is really the main player right now.
That's perfect. All right, Marcus, it looks like you are next if you want to jump in.
Hey there, everyone. Like I said, as Pamela was so kind to introduce me, my name is Marcus Deegan. I'm the legal director here at People's Legal Aid. We are an upstart little nonprofit here in town who acts as we're a nonprofit law firm dedicated to all things tenant side and landlord tenant, specifically doing eviction prevention, as well as helping folks with dealing with the back end money issues that can emerge from landlord tenant relations. I got my start at Utah Legal Services and their esteemed housing program. I was with them for 2.5 years in total. And then I moved over to People's Legal Aid to start participating in the supplementary work that People's Legal Aid tries to do that Utah Legal Services simply is not able to do amid all of their hard and diligent work. So we've existed for about 2 years now. We're still a small shop, but we are in front of Judge Parker in the Salt Lake District every single week. We're looking to expand operations more, but we are at least vigorously operating there. And we do take legal consultations from folks in, and I should have this more memorized off the top of my head than I do, but we take at least legal consultations and assess cases for more ongoing extended services representation for the counties, not just of Salt Lake, but also Davis County, Ogden, and I believe Summit and Wasatch as well. Anyone who's looking for more information about what we do, please do not hesitate to reach out to me directly at my email address that I'm going to go ahead and pop into the chat line right now. And so I'm going to talk a little bit about the reason why we're all here today, eviction expungements, and about the background of this issue, why this is an issue at all, and what's been done before. I don't have any presentation materials. My particular portion of this presentation has to do with just the foundational need for the expungement statute to be outlined by my colleague, Mr. Lloyd. As I'll be outlining in my own remarks, this particular corner of the law is, in this one advocate's opinion only, I do not speak for People's Legal Aid as a whole on this, rather underregulated. With there being this limited regulation, I only have so much to visually show, so I'll be focused instead more on just describing a phenomenon that operates outside the typical confines of a regulated legal operation. So as we all know, filing a lawsuit is never just the assertion of a legal right. Of course, it is that much, but it's also many other things. It's an expression of futility, a way of saying that I've lost the ability to productively communicate with the other party. I need to bring in a branch of government to address the situation. It's an affirmation that the law stands as the only reasonable remedy for a dispute rather than engaging other mechanisms of dispute resolution. It's an enforcement and ratification of policy norms enshrined in our statutory system. It's an enormous event in a human being or being's life in a way that reverberates beyond just the immediate parties. It's all these things. But most importantly, for today's purposes, a lawsuit is the creation of a public record, a record of both the lawsuit existing at all, of what happened in the lawsuit, including the entry of interim orders like eviction orders, and it's a public, and if the lawsuit concludes in a judgment, it's a public register of the judgment itself. Now, a public record, in turn, creates publicly available information that can be used to evaluate one's creditworthiness or otherwise one's worthiness to engage in a new business transaction like a landlord-tenant relationship. And that's what we're here to talk about today, the existence of an eviction lawsuit as it affects a person's ability to seek new rental housing. Now, I talk all the time to people who are dealing with landlord-tenant issues, and there is no refrain I hear more frequently than, well, I just don't want an eviction on my record. I'm just terrified of having my credit hurt. And I always have the quite unpleasant job of explaining to them that, well, a tenant's record is not just a single document held by a single entity. It's many documents held by many entities, and no one entity does everything all the exact same way. Now, on top of that, how information about an eviction is actually used to evaluate creditworthiness can actually come in principally two different umbrella forms. First, there's the acquiring of a tenant screening report, a type of formalized credit report, the generation of such reports being regulated by the Fair Credit Reporting Act, or as I'll probably foreshorten it as in this presentation, FCRA, Fair Credit Reporting Act. When a landlord declines to rent to someone based on the contents of a tenant screening report, the tenant is entitled to demand what's called an adverse action letter that provides some basic information under FCRA. But crucially, there's no requirement that the prospective landlord identify what specific information in the report was used in deciding not to rent to this person. The second method for evaluating creditworthiness in a residential rental setting is simply acquiring information that is already in the public record, the existence of a lawsuit or the existence of a judgment in such a lawsuit. The latter type of service is one that is increasingly more common, not just in Utah, but all across the country, in no small part because even those modest requirements from an adverse action letter and other requirements of FCRA simply don't apply. These are just publicly available records, and people are allowed to pass on information about what's in the public record. But regardless of how a prospective landlord acquires this information, either one of these sources can make for a ding against somebody seeking to find a new rental. Sorry, we don't rent to people who have been evicted before. Sorry, we don't rent to people who have still outstanding judgments from former landlords. You get enough landlords using a particular tenant screening report, or you get enough landlords subscribing to a service that provides public records info about who's had an eviction order entered against them, who's been sued for eviction, or who owes who what money. And soon enough, anyone who's ever been on the wrong side of a landlord is going to have an extraordinarily hard time finding a new place to live. Couple that with the instances where a person fails to leave a forwarding address after an eviction order is entered, or there was no eviction lawsuit and the person moved out early due to an abusive roommate situation, but didn't know that they had rights to force break their lease under the Fit Premises Act. Default judgment is bound to enter in a way that may not be known about for potentially years later after their life stabilizes and they're trying to find a new place to live. Furthermore, and to get to the efforts that have been made up until this point, the rules of judicial administration here in Utah, and this is true across many states, this is not unique to our state, but our particular judicial administration rules create a very heavy presumption that public records remain public, including records of what goes on in a court, and that either the judicial administrative commission or the legislature will make a point of speaking out on which records are so sensitive that they must be reclassified as something other than public in a way that they're not publicly accessible. In our Code of Judicial Administration, specifically the section of Rule 4-202, there is a multi-part test, and once again, in this advocate's opinion, only a rather unduly arduous test against which reclassifying a record to being sealed is tested. And I can attest from my own personal efforts, both at Utah Legal Services and here at People's Legal Aid, that under the traditional test outlined under Rule 4202 and the other relevant sections of the Judicial Administration Code, that this test is fairly burdensome. And indeed, it would seem as if even in plenty of cases where the case is fully resolved, everything is done and completed, no more dispute, that there is no level of pleading the multi-part factors in this test that could convince some judges to ever seal a record of an eviction. This unfortunately creates certain barriers, especially for individuals who maybe got their case fully resolved, but there are certain tenant screening reporting entities who only report on whether or not a tenant was sued in an eviction lawsuit, no other detail, or rather, there is further detail if the prospective landlord feels like paying more money for a more expensive credit report. Who wants to do that? So the less expensive, more readily available credit reports just show, oh, this person was ever sued in an eviction action. Doesn't matter how it resolved. If this person ever had to be sued, they must be a vector for trouble. Therefore, I'm just not going to rent them. And that's the end of the story. And if this person cannot persuade the judge presiding over their case that they meet the standards of seeking to have their case reclassified as sealed under the current judicial administrative code, then that record remains public, and any other landlord who feels like refusing to rent on the basis of that record existing at all is entitled to do so. So that is what brings us to the present expungement statute. In this most recent legislative session, the legislature deemed appropriate to pass a bill that allows for more clean expungement of records, such that not only are they sealed from being public records, but in fact, the tenant can truthfully say that the matter did not happen at all. And with that, I'm already stealing the thunder of my esteemed colleague, Mr. Lloyd. Mr. Lloyd, take it away.
No, not at all. You were probably going to say it more interestingly than I will. Even kind of just jumping on top of what you were saying, Marcus, I've even had cases where, an eviction's been filed, eventually the case is resolved, claims are settled, and then the tenant wants to seal the record under the previous rule that we had before this statute, and even in cases where the landlord was okay with sealing the record, some judges would say, well, still doesn't meet the requirements of that Code of Judicial Administration. So even though both parties are on board with it, and even though both parties are okay with sealing the record, it still can't be done. And I think that just really.
Just to put a finer point on it, Nick, you're describing a phenomenon, and I've been a part of some of these, where it was not just the landlord elected not to object to the motion, no opposition was filed, but the landlord actually, in writing, stipulated to the record being sealed. And the judge still said, no dice, this is a public record, it remains public.
It really just goes back to, the point that this is something that can affect people. And, from the landlord's perspective, yes, if you have someone coming to you wanting to rent, and you look at you look at Court Exchange and you see, oh, they're coming to me from being evicted for non-payment of rent, that's going to probably raise some red flags for a landlord. But at the same time, I would say the vast majority of my clients, if someone's been evicted in the past, they're okay with renting to them so long as they've taken care of things. They've got back on their feet. They've settled any amounts owing, and they're moving forward with their life. Most landlords aren't out there just trying to say, we're never going to rent anyone who's been evicted. Most landlords are out there realizing that people need a second chance. And really, especially with Heather Lester and all the resources that she has, there's a lot of opportunities for people to be able to receive assistance and getting back up on their feet. That's one other thing that I was just going to add earlier too. I know a lot of people, a lot of the presenters here are putting their contact info in the chat. Feel free to lean on them if you come out to work on one of these calendars. Obviously, the pitch for this CLE is come out and work on one of the calendars. And all these people, especially Heather Lester, they're great resources for you when you're going to be helping out some of these tenants here. So obviously, I'm here kind of as the counterpoint. I represent landlords, basically. if you come out and volunteer on one of these calendars, I might be the person on the other side who you're talking with and who you're negotiating with. But really,
And
I
Nick,
think, oh yeah,
just remember that we do have some attorneys joining us who also are here because they want to represent landlords and they're interested in learning your side too. So you have some friends in the.
Well, I'll put my contact info in the chat too, and feel free to reach out to me if you want to represent landlords.
Thank you.
But really, I think the fact that that we have both sides of the landlord-tenant litigation bar here really just goes to show that really both landlord advocates and tenant advocates are on board with this new expungement bill. Obviously, Marcus and Heather and Pam have outlined the benefits to the tenants from being able to have an eviction record expunged. But at the same time, landlords look at this and they think, well, this is an incentive to, help people settle their debts and to get people to want to pay off, back rent that they might owe. And then at the end of it, people can pick themselves up, people can go on with their lives, and people can move forward. And really, that's kind of the underpinnings of what brought about this bill. I'm going to skip ahead a little bit. Really, this is a bill where it's still very new. Marcus described the inadequate previous mechanisms for trying to get a record sealed, but really, this is a bill that was passed in the last week of the session, and a lot of both the tenant advocates and the landlord advocates might have said, well, we would like it a little bit different, or we would like a couple more things in here that we didn't quite get, but legislative session is only 45 days, so let's get something in place right now going forward so that we actually have some way to expunge eviction records over the next year, and we're not just stuck until the 2023 legislative session, and all those people in between then are just out of luck. So if you're on the calendar and we're working through one of these issues, and you see, hey, I think that there's a deficiency in the law that's been made, or I think that the law could operate better this way, I would say feel free to come back to us. We're actively trying to figure out how we can improve things. And like I said, this is a brand new law that, like most things, it might be a little bit clunky out of the gate, but we want to get to a point where really this can be an effective tool for everybody in the courtroom and helping to resolve cases and move on with everybody's lives. So, okay, can I get the next slide, Pam? Thanks. Okay, so in the law, generally there's three ways that an eviction record can be expunged. First is an automatic expungement. The second is an expungement by petition, where the tenant goes to the court and files a petition to expunge, much like a criminal expungement. And then the last one is a stipulated expungement. So all are a little bit different. All have their own requirements and when they apply and who they might apply to. But we'll go through those because each one of them might apply to a case that you appear on one of these calendars on. Okay, so the first one, the automatic expungement. This is expunging an eviction case when the case is dismissed. So there's no filing required, filing either by the landlord or by the tenant. The requirements to it are that the entire case is dismissed, basically that it's resolved, that there's no appeal, and it's been at least 3 years since the eviction was filed. So say you appear on the eviction calendar, and your argument to Judge Parker is that this is an improper eviction case. The landlord hasn't met the requirements of the eviction statute. For whatever reason, you should dismiss the case. Judge Parker agrees with you. He dismisses the case. You can then go back to the tenant and let them know, hey, case is dismissed. So long as the landlord doesn't file an appeal, 3 years from now, that eviction will automatically come off your record. That's something the court and the court staff do on their own. They screen for that. That's all in-house for them. At the same time, this only applies to evictions filed after July 1st, 2022, which is kind of why we're doing this, this CLE here. So this is another situation where, say you're on an eviction calendar and the landlord wants to keep them in the unit so long as they're willing to pay. You know, you work with Heather to get some money to get them caught up. Money gets paid and the landlord can stay in their unit. You know, at that point, and the tenant can stay in the unit, excuse me. At that point, the landlord, they don't have a case anymore. It's been completely resolved, so they'll dismiss the case. That's another situation where that eviction would be expunged after the 3-year period. Now, I would just note to keep in mind that if you are reaching an agreement to get caught up and to keep a tenant in their unit, it's probably going to be a little more beneficial to try and get a stipulation to expunge the record, which we can talk about a little bit later, but that's a different method of expungement. So we'll go on to the next one here. So the second way that an eviction record can be expunged now in the state of Utah is by petition. So this only applies to evictions that are for non-payment and a tenant staying after their lease. You know, there's a few different types of evictions in Utah. You know, you can have a pay or vacate if a tenant falls behind on rent. Likewise, if a lease ends and a landlord says, hey, your lease is ending, you got to leave, and the tenant doesn't leave, you can have an eviction based on that. At the same time, there's a couple others. You know, you can have an eviction based on a comply or vacate where a tenant is violating the terms of a lease agreement. Say they have a pet in their unit when they're not supposed to. You know, a landlord gives a 3-day notice that says you have 3 days to comply with getting the pet out, comply with the lease, or you got to leave. At the same time, you can also have a 3-day notice to vacate without the opportunity to comply for criminal acts. You know, say a tenant commits a criminal act on the property, say they, you know, assault another resident or whatever they may do. The landlord can just give them a 3-day notice to vacate. And then if they don't vacate within that time, they can file an eviction case. So really getting back to the expungement though, the expungement by petition really only applies to the non-payment and staying after a lease end. You know, as the bill was being debated, there was a policy consideration that if a tenant is, you know, committing a criminal act on the property or getting evicted for causing a nuisance on the property, if there's a little bit higher of a public interest in future landlords being able to know about that and being able to know about those potential problems. But, you know, non-payment issues and things like that, those are the kind of things that if people settle up their debts and everybody can move forward, that it really ought not to hinder people, ought not to hinder tenants going forward. So under the expungement by petition, any amounts have to be satisfied. Obviously, if there's been a judgment entered in the case, that judgment has to be satisfied. On top of that, this is the kind of situation where, because it's not just the court staff screening for expungements themselves, the tenant has to file a petition. There's likely a filing fee associated with that. That was one of the debates of the bill, is whether or not the courts could be prohibited from requiring a filing fee. And ultimately, the legislature decided that they wanted to put a little bit of that cost on the tenants to do that expungement. And then on top of that, in order to have the record expunged by petition, there has to be no objection from the landlord. A lot of times, well, I shouldn't say a lot of times, sometimes there are multiple issues underpinning the case. You know, it might be that someone is causing a nuisance or causing noise disturbances in the middle of the night and their landlord wants to evict them. But at the same time, that tenant is also behind on rent. You know, in order to file an eviction based on the noise complaints in the middle of the night, the landlord might have to go to surrounding neighbors, you know, go to people who have been experiencing this and get them to come as testify as witnesses. On the other hand, sometimes an eviction for non-payment is viewed as a little bit easier because the only person who has to testify typically in that situation is the manager or the person who served the notice, the person who's associated with the apartment complex, with the landlord. So it might be that, you know, a person was evicted for non-payment of rent, but really there were also all these other issues going on as well. the landlord might want to object and keep that eviction on the public record based on some of the other issues. But honestly, and frankly, as my office anticipates these expungement petitions being filed, I would think that there's really not a lot of cases where a landlord would be objecting to a petition for an expungement. Those are pretty rare cases, but that was one thing that was put in the law as well. So I'll just jump forward to the last one, and that is a stipulated expungement. So this is the section of the code here, and this is all it says. All parties to an eviction may stipulate in a settlement agreement to the expungement of that eviction. So that's pretty broad language. When you look at the automatic expungement and the expungement by petition, there's a lot of constraints on those and requirements. Stipulated expungement is pretty wide open, so long as both the plaintiff and the defendant can agree upon it. And honestly, I think this is where a lot of the expungements will happen, especially for people here who might be appearing on the eviction calendar or the debt collection calendar. And so really, this is an important tool to be aware of and to keep in the back of your mind as you appear on the calendar and you go to the plaintiff's attorney or the defendant's attorney or whoever it might be and say, hey, what can we do to work this out? We want to be able to expunge the record. Is there something that we can come to an agreement on to make that happen and to make, the landlord whole as well? And so really it's a situation where now we have these tools and it just comes down to the practical of how we apply these in the calendar. So I think at this point, we're going to open it up, kind of have a little bit of a panel discussion.
I was just going to add real quick on the end of Nick's comment there. When it comes down to this, and I put a comment in the chat too, but when it comes down to stipulated expungements, it's kind of exciting going forward after July, because the main thing, not just, getting money, solving the situation, making sure there's not a balance. Usually if it's went all the way to court, it's probably because either one of the parties hasn't acted, and it's generally the tenant. But if we can help as far as mediation goes, not just with the agreement, and then all of the agreements that you guys will put forward as well, if we can help to maybe repair that relationship, because most of the time we hear tenants are not engaging with the landlord. There's either a fear aspect or they're not really serious. Maybe they're not going to actually do anything. And then of course it triggers a escalated process. So not only do we help to regulate and rally, if you will, resources, but with the mediation specifically, the neutrality that we bring, we want to repair that relationship with the landlord. So maybe there would be a re-signing situation when it does come to the end of the term, or at least, in whatever aspect, just repair the relationship and facilitate the communication between the two, because that's obviously where it likely went sideways. And so I just wanted to add that as far as mediation goes. We really, sometimes with case management as well, mediation doesn't do case management, but we do work directly with case managers at many, many different agencies. So we have to have that case management aspect where they're holding them accountable to, financial education classes, landlord tenant, how to read your lease classes, any kind of 101 type of things that case managers have that accountability, or they cannot, or they will not help them. So that's also something that can repair that relationship. I just wanted to add that part too. Thanks.
And if I can likewise just throw in a quick shout out about this, this particular portion of the slides that we have up right now about stipulated expungement. This is definitely the portion of the statute that I personally found myself getting most hyped about, because as all we lawyers in the room know, in negotiations, there's not really any rules. It's whatever you're willing to offer, whatever the other side's willing to accept, and vice versa. And so it really creates this nice, big, broad, open field for the parties to be able to come together and be like, all right, what are the concerns you have here? What are the needs that you, landlord, need to see met in order to assuage your concerns about getting this thing sealed up? So it creates this nice, big, broad opening to try to broker a settlement and improve a relationship, or at least better the history that's been left behind in that relationship, to be able to say, hey, things have happened, but now going forward, here's what things are going to look like, and creates a way to still clean up the past.
And Brooke has a
And I
really good
think-
question about this. Oh, sorry.
Oh, I was just going to bring up a point that Nick had before we joined the meeting. One of the things that's interesting is there are housing issues on both the immediate occupancy calendar, but also on the debt collection calendar. Because when an action is first brought and you're trying to figure out, can the tenant stay? Do they need to vacate? What are all of those issues? Often the debt side of it is reserved for later. And so it may be 6 months, it may be 2 years, it may be even longer than that. But a debt collection action will come that started out as an eviction. And so part of this whole new scheme is determining if you're doing a stipulation, when. Are you doing it on the side at the immediate occupancy to get it in the record so you can start relying on that? Or are you going to still wait and reserve those debt collection issues? So I'd love to hear thoughts on that from others as well.
Yeah, no, it's one of those things that I think each situation is going to be different, what the parties are willing to agree to. There are cases where, say you're at the immediate occupancy calendar and you've reached an agreement that, okay, a tenant's going to leave, they're going to move on within a certain period of time. At the same time, the landlord doesn't know what condition the unit's going to be left in. Ideally for everybody, the unit's left in good condition and there's no cleaning and damages that are assessed. Sometimes that's not the case. And sometimes there might not be a final number of amounts owing until after the tenant's out, until we get to the debt collection calendar. But at the same time, I know a lot of situations. I just had one with Marcus the other day where we agreed to expunging a record at the immediate occupancy hearing before they were out of the unit. So it's really something where there's a lot of latitude in the law based on what the parties can agree on. One other thing I was just going to say too, Brooke has a really good question here in the comments. It says, is there anything that states the expungement by petition and stipulated expungement relate to evictions after a specific date, or can there be evictions that are backdated? So remember there was that requirement on the automatic expungements that they be filed after July 1st of this year. This section of code here that deals with stipulated expungements doesn't have that. The statute's silent on it. So it really is something that gives some pretty broad latitude, some broad discretion, I think, to the courts to be able to expunge it once the parties agree upon it. So you might be on the debt collection calendar and you've inherited an eviction case that was filed back in March, but now in July, we're dealing with amounts owing. I think that the possible stipulated expungement is definitely still on the table based on what the parties can agree on.
So another thing with this, the courts forms committee has been working, and they asked for input from both Nick and the Cullimores and through our office to look at an approved form. This has gone through the committee and been approved as of June 18th. So if a petition needs to be filed, this is available on the court site, and you can figure out whether to help or whether to just allow the tenant to do it on their own. But it is available, and then they also have a sample order that's based on the petition, so you can give to the judge for that. So those are available. We'll also send these out with some additional materials to all of the people attending. And then we also just kind of come up with a very basic, like, what does stipulated language even look like? How do you even start with this? So this is just a very basic, generic starting point, but it gives the idea of the types of issues that you're going to want to think through, of whether all of things have been paid, when payments will be made, when do they have to vacate. All of those issues are important to be considered when you're doing the stipulated language.
Yeah, just one thing I would add to jump on that. you know, because this is a limited scope representation calendar for volunteers, you know, generally speaking, you're probably not going to be involved later on. Most of these cases are ones where you're dealing with an agreement to vacate or an agreement to pay funds, whether that be a one-time payment or whether that be a payment plan stretched out over a period of months, you know. And if you're not involved with the case at that point, just keep in mind and keep in the back of your head, okay, how's the expungement going to work once we get to the end of this, you know, when the tenant doesn't have me there to assist them, because those are important things to put in the stipulation as well.
And to make sure that you're explaining to the tenant, whether that's in a recap email sent to them, reminding them of the steps that they'll need to take and the different milestones along the way. Anything that can help give them clarity and additional information is going to be helpful for that.
And I will say for myself, when working with any of these folks, really send that reminder in an email. If you're just describing it over the phone, there's no way these folks have any hope of remembering that offhand. Since we're coming towards the end of our time, and I'm sorry, I was having a little audio trouble on my end. Did we already answer the other question in the chat from Angela?
I don't think we've gotten to that one yet.
Yeah, I don't think so.
It's just about service of the petition. Nick, it's normal Rule 6 or Rule 5 service, right? Not Rule 4.
Yep.
All right.
Just Rule 5 is my understanding.
That was my understanding as well. Yep. Just service by mail should be sufficient, or email, or what have you. I'll also just throw a shout out to amid us plugging the calendar. I threw out my work email into the chat line earlier for anyone who is joined since the first 10 minutes. I'm going to drop it in the chat line again. Anyone who feels like volunteering on this calendar, please feel free to hit me up if you're hitting any curiosities in the case or any weird aspects of the law you don't understand. I thrill to and love talking with folks about their experiences volunteering on this calendar, and I'm happy to support any way I can.
And I just put mine in there as well. That's what I manage the calendar, so I try and help provide support where I can. And if you need mentors, we try and provide that as well, or any information we have. There's lots of information and there's lots of people willing to help. Make sure that you don't go in there blind. And no, I just want to second what everybody said. I appreciate working with Nick and his office and all the other landlords out there that their attorneys are very willing to work with you and to not be nervous when approaching these. They're very, very willing to work, and if not, that's just work it out anyway. So you will find a solution. I think this expungement really provides us a lot of effort to work to try and make things better for tenants as they settle some of these debts and move forward.
And it looks like we have come to the end of the CLE. So thank you everyone for joining us, and to all the presenters, thank you so much. It was really helpful and great information. If anyone has any questions or wants to learn more about signing up for the calendar, reach out to Keenan, and we'll see you next time. Thanks.